j'ai la charge.
Ladies and gentlemen, I have been asked to moderate this panel, a panel entitled Humanization of Public International Law in Practice. It seems to me that there's a very close connection between the subject addressed by the previous panel and the subject that this panel will address. I would say that the two panels actually complement one another. Speaking in a personal capacity, I would say that the four speakers who accompany me on this panel, these four speakers have a heavy burden of responsibility. They have been asked to answer a question regarding reasons of state. Are reasons of state still something that should prevail over the reasons of humanity? Or, to rephrase that, can we in fact deem that reasons of state will withdraw, retreat behind that of humanity? Without much further ado, because we are already running somewhat late, I would like to call our first speaker, a judge at the International Criminal Court, His Excellency Judge Peter Kovács. Mr. Kovács will give us an overview of the topic that we shall address as a panel. Judge Kovács. Thank you very much. Thank you, President. Well, first of all, a big thank you to the Curatorium. Thank you so much for inviting me to speak. I was, of course, an alumni myself of the Academy back in 1987, so that was quite a long time ago. I come back now in this new capacity. Regarding humanization, I can give two meanings to humanization. On the one hand, I would say that it's a reality, and on the other, I would also say it's a modus vivendi. It's an objective and also a modus vivendi. In terms of the first, I think that the purpose, the objective of international law is to help us progress as humankind, facilitating cross-border judicial cooperation with a view to contributing to the development and protection of our environment, or indeed contributing to a better prosperity, better living standards, resolving health issues, and at the same time, of course, promoting cohesion within human society. Regarding the material side of things, I would say that essentially we're talking about human rights. That has already been addressed by previous speakers, and I know that it will be addressed by Judge Sicilianos in a moment. So, in other words, the subject matter that I would like to address together with you is the procedural side of things. Procedural matters, and by that I mean the participation and the role of human beings, individuals, and also different communities when it comes to the creation of international standards and their enforcement. And therefore, I would like to speak about customs, ultimately. Customs are based upon state acts, of course, to begin with, but ultimately there are a lot of obligations which are obligations of prohibition. Do not torture, do not steal, do not rape. Obligations as prohibitions. And these rules, I would say, are easy to respect. They should be easy because in our day-to-day lives we don't steal, we don't rape, and nor do we commit acts of torture. And we don't just not do these things because it's prohibited by an international or national rule. We don't do it because ethically we're simply not predisposed to do that sort of thing. Then, with regard to the other aspect, when it comes to the shaping of custom, what I think we can see right now, what we find, is that with the multiplication of marriages, unions between individuals of different nationalities, different colors of skin, also with the birth of children, again from different ethnic backgrounds, different colors of skin, also the progressive space gained by women in society, in industry, in administration, nationally and internationally. I think that all in all, these phenomena have allowed us to move beyond certain sexist criteria, nationalist criteria, certain preconceived ideas. We've moved on from that, and thus we find that the principles that were proclaimed back in 1948, these principles, decades later, can be deemed as forming part of our custom. So it's a human factor, if you like. It has its value when it comes to the perception of these matters, the government's perceptions of these issues, juris civis necessitatis, incorporating that into custom. So what I'm trying to say is that the behavior of individuals, of human beings, contributes to the way in which states reflect the way in which governments act. It has an impact. Regarding humanization in the drafting and elaboration of international treaties, well, it can be direct participation or indirect participation. I think you know this full well already. I could refer you, for instance, to the ILO, the International Labour Conference, the ILC of the ILO, with tripartite formations or indeed parliamentary assemblies. The Council of Europe is one example, or the former Western European Union and its parliamentary assembly, assemblies that bring together people who represent different political shades, different governments, but who nevertheless engage in participation. Of course, they have their different ways of participating, and that will depend on the internal rules and statutes of each organization. Sometimes it's designed to give political support to some treaty-based activities, but in other cases, Council of Europe, for instance, when we drew up the Charter on Minority Languages, the Committee of Ministers of that organization gave a mandate to government experts to work on a document which was drawn up by the Standing Conference of Local and Regional Authorities of Europe at the time. Regarding the Framework Convention, there the Committee of Ministers deemed that this was a document for inspiration. It could be used as a reference. I refer you here to Resolution 1201 of the Parliamentary Assembly of the Council of Europe, to what it has to say on this matter. I mean, there's a whole plethora of other documents that refer to this also. Then, regarding the Rome Statute and the drafting thereof, preparations for that, we've already touched upon it. There, the governments were prepared to accept that the forum for negotiations shouldn't be one that completely sidelines NGOs. Civil society should not be completely outside of the room. I mean, stricto sensu, the meeting hall was for government representatives, but nevertheless, NGOs who were favorable to this idea of setting up an international court or international tribunal, these NGOs were able to access the building, they could come into the building, and they were able to organize so-called side events or parallel events, where they could present cases, where they could also make their opinions known on certain texts, certain versions. So indirectly, I think that they were able to influence the attitude of states, particularly when it comes to being favorable to the idea of a future permanent court. It became quite a popular idea, and ultimately it led to the approval of the draft, as you know. Then, moving on to another aspect, if I may, the humanization of practice. When we're talking about non-judicial monitoring mechanisms for international conventions, here I would say that there's humanization in the sense that, and I think you know this, when it comes to triggering different monitoring procedures, there's a human being, obviously, who has a role to play, either optionally. It can be on the basis of an option. For instance, if it's a convention, it might already be compulsory, so optional, compulsory. Some organizations have also acknowledged the principle of collective complaints, so class actions. Another aspect that I would like to mention is participating in the monitoring mechanism. And here I would like to refer you to the current activities of the Cultural and Economic and Social Committee, its activities, which they listen to NGOs when they look at state reports, they consult civil society, or there's the subcommittee attached to the Intergovernmental Committee that works on the European Social Charter. Here again, you you see a result, you see an outcome. A certain place has been guaranteed for the representatives of workers and for the representatives of employers. So both sides of the social dialogue are represented. There are also a number of international conventions, the Charter, European Charter on Minority and Regional Languages, or the Framework Convention on the Protection of Minorities in Europe. Again, in these instances, the governments have accepted that the committee of experts, or indeed the monitoring committee for these texts, these instruments, are able to meet with minority representatives, and these minority representatives can convey their opinions to the monitoring committees. They can tell the committee how they feel about the implementation of these texts by the governments of their countries regarding their rights. Then, humanization in the practice of the judicial functioning of all this, and I think here we can make a distinction into 5 different sections, I would say, broadly speaking. First of all, amicus curiae as a factor of humanization. You have here regional tribunals or courts for human rights, for instance, or you've got different criminal tribunals and criminal courts. Generally speaking, in their statutes, there is a guarantee provided, regarding the participation of amicus curiae, friends of the court. Generally speaking, we're talking about NGOs, we're talking about representatives of civil society, and we're talking about those entities that wish to work towards a better protection of human rights. In terms of their contributions, I would say that these amicus curiae do their best to help resolve a legal dilemma, a legal question, and the judges, of course, will make proposals. Ultimately, it is the judge or the court that decides whether to accept these proposals or not. But anyway, their vision is, generally speaking, their vision is that you should move towards a solution that is more generous and more promising when it comes to promoting or defending, indeed, human rights. Then, another branch, if I may call it that, still under the same heading. Here we're talking about litigation, human rights-related litigation before the International Court of Justice. Judge Benuna spoke about that earlier on. He spoke about diplomatic protection, for instance. But of course, when you're talking about the former advisory opinions, for instance, with regard to Hungary, Romania, Bulgaria, you may remember that in those countries there were massive human rights violations which underpinned those advisory opinions. As things stand right now, what we notice is that notwithstanding the monitoring guarantees that are enshrined in the treaties and in the conventions, protection against all forms of discrimination, based on race, for instance, this convention has now come before your court. It's on your agenda, so to speak. We know that, and therefore, justices, you have already given some decisions on such matters. So it is something before you. Another aspect that I would like to mention, if I may, and this regards the accused. So investigations before international criminal courts and the rights of the accused. I mean, we are able to achieve a human form of justice. This was said earlier on as well, by lifting the veil. Robert Badinter, you may remember, spoke about lifting the veil. Very important in terms of observing the rights of the accused. Another aspect is the victim. Respecting the interests of the victim. That's in terms of participation before international courts or tribunals, being given compensation, reparation, and also assistance to be provided to the victims. And then finally, humanity as a notion, I think, is very much present in the case law of the ICJ, for instance. I mean, the advisory opinion, on the issue of Gabčíkov Nagymaros, or the nuclear arms case, the Almaty case as well. This issue was very much present in those opinions. For instance, when the monuments were torn down by Islamists, that again was raised, and the concept of humanity was part of that wording. I come to my conclusion, Chairman. It seems to me that humanization is already a fact. It's already happening, although it could be, I think, done more forcefully going forward. Maybe I'm being very optimistic, but I think that ultimately all international law experts are optimists by nature. Thank you very much for your kind attention.
Merci beaucoup, Monsieur le juge.
Thank you very much, Judge Kovac. The second speaker of our panel is Professor Linos Alexander Sicilianos, who will be speaking to us about the humanization of diplomatic protection. He's a member of the Curatorium, professor at the University of Athens, and former president of the European Court of Human Rights. You have the floor. Thank you very much, Chairman, judges, dear colleagues, dear friends. The institution of diplomatic protection is a typical example of the humanization process of international law, the subject of this conference. This process started, as we know, just after the First World War, with the setting up of the League of Nations, the setting up of mixed arbitral tribunals, and the conclusions of treaties for minorities, which set out to afford protection to individuals and not only state interests. In other words, the humanization of international law spans a period of roughly 100 years, which coincides, broadly speaking, with the centenary of our Academy during this century. The Academy, in fact, has been a privileged place of reflection about the role of an individual in international law since Jean Spiropoulos' course in 1929 to date. Diplomatic protection has evolved during the same period, in particular since the Mavromatis judgment of the PCIJ in 1924, up to a number of major judgments of the ICJ and the European Court of Human Rights, the most recent of which was delivered on the 28th of April 2023 in the case Georgia against Russia. The work of the International Law Commission have also played a major role in that respect, as was discussed in the previous panel. And in order to briefly describe these developments, I would first of all like to speak about the transformation of the legal nature of the institution and the broadening of the scope of diplomatic protection. As regards the nature of the institution, we know that according to the traditional approach as expressed by the PCIJ in Mavromatis, when the state decided to introduce diplomatic protection, in truth, as the court pointed out, it is in fact invoking its own right. Almost 50 years after this state vision of the institution was reasserted by the ICJ in the Barcelona Traction judgment. The court said that the state is in charge of deciding whether it will afford protection, to what extent, and when it will stop this. In other words, the state has a discretionary power over all aspects and during all the phases of the exercise of diplomatic protection. Conversely, the individual was almost absent from the process as a whole. This vision, based on legal fiction, is outdated today. Diplomatic protection isn't merely a state right, but mainly constitutes a way of protecting the rights of the injured individual. And as the ILC pointed out, in truth, the state isn't only invoking its own right. In actual fact, it is also relying on the right of its injured national. This new outlook is corroborated by the recent case law of the ICJ. Indeed, we know that in the Diallo case, the court held that the exercise of diplomatic protection by the Republic of Guinea in respect of its national primarily concerned the violation of his individual rights as an individual. And the court, in its judgment, in fact, on the merits, found a violation of the International Covenant of Civil and Political Rights. Likewise, we encounter other ideas in judgments delivered by the European Court of Human Rights, for example, in the interstate cases, Cyprus against Turkey and Georgia against Russia. These cases are as interesting from the standpoint of awarding compensation to the injured person. In the Diallo case, Guinea claimed compensation on the basis of the alleged harm sustained by its national, and the ICJ established the amount of compensation on the basis of the violations of human rights sustained by Mr. Diallo. Likewise, the Republic of Cyprus and Georgia have provided the Court of Human Rights with lists of injured persons in the context of the pre-quoted interstate cases. The Strasbourg Court calculated the amount of compensation on the basis of these lists, and again, having regard to the seriousness of the violations found. Moreover, the court said expressly in the operative part, unlike the judgment of the ICJ, therefore in the operative part of the judgment Cyprus against Turkey and Georgia against Russia 1 and 2, that the amounts awarded would be distributed by the applicant governments to the individual victims, specifying the precise amounts to be given to identified groups of victims. In other words, the applicant governments consulted the victims and their families regarding compensation, which was claimed, and the European Court, ordered the states to transfer these amounts to the injured persons and their families if need be. This jurisprudential practice, which is becoming widespread, clearly reflects the recommendations of the ILC, according to which the state exercising diplomatic protection should have regard to the views of the injured individuals as regards compensation to be afforded, and give to the injured person any compensation obtained by the responsible state, subject to reasonable deductions. In the draft articles on diplomatic protection, the International Law Commission equally recommends that the states should duly take into consideration the possibility of exercising diplomatic protection, in particular when major harm has been caused. This recommendation was also introduced into the Strasbourg Court's judgment HF against France of 2022. The court quoted the ILC and recognized that, admittedly, the state doesn't have an obligation to exercise diplomatic protection. Nonetheless, it shall consider this possibility, afford guarantees against arbitrariness, in particular in cases of alleged violations of the prohibition of torture, like in that case. This leads me on to the second part of my intervention, namely the broadening of the scope of diplomatic protection, ratione materia and ratione personi. I have already alluded to the broadening of the ratione materia scope, saying that diplomatic protection today is a way of protecting human rights. We know, indeed, that at the outset, diplomatic protection fell into the narrow framework of the minimum standard of treatment for foreigners. Today, given developments with regard to the rights given to individuals, the scope, ratione materia, has extended and been extended, and henceforth covers human rights. Along the same lines, we have Article 36, Paragraph 1 of the European Convention on Human Rights. That provision recognizes the right of intervention of states parties for the benefit of their nationals who lodge an application against another state party. On several occasions, the European Court has applied this provision. It considers that the intervention of a state which takes up the cause of its national constitutes a form of diplomatic protection. This right of intervention is exercised on the basis of all human rights laid down in the European Convention of Human Rights and its protocols. I would also like to refer to Article 46 of the EU Charter of Fundamental Rights, which expressly envisages diplomatic protection and consular protection as a right of the EU citizens in general, which immediately leads me on to speak about the broadening of the ratione personi scope of diplomatic protection. We know that according to the traditional approach, diplomatic protection could only be exercised for the benefit of nationals. The absolute nature of the so-called principle of the nationality of claims was upheld in a striking way by the U.S. Mexico Claims Commission, which in no uncertain terms stated in 1931 that a stateless person person was at the mercy of any state authority and that no state could, in fact, come to their assistance. That way of seeing things today is difficult to accept. Thus, the ILC has underscored the particular vulnerability of stateless persons and, relying on the Convention on the Reduction of Cases of Statelessness, has decided to relativize the principle of the nationality of claims. A state can indeed exercise diplomatic protection regarding a stateless person if the latter, on the day of the damages and on the day of the official filing of the claim, has their legal and habitual residence in its territory. In other words, in the case of stateless persons, residence replaces nationality. Likewise, mutatis mutandis for persons which enjoy refugee status without just sticking to the principle. Only looking or basing oneself on the principle of the nationality of claims would deprive another particularly vulnerable group of protection, i.e. refugees. Hence the need to grant refugee status to people if that person has their legal and habitual residence on the territory. The case law of the International Tribunal for the Law of the Sea, in fact, adopts the same view with regard to the protection afforded to members of the crews of ships, which was mentioned this morning. In the cases Saiga No. 2, Virginia, and North Star, the tribunal held that the vessel, everything on the vessel, and hence the people on board are to be seen as a single entity connected to the state, the flag state, which can protect them. Therefore, the logic of the rule is to afford effective protection to the members of the crew, given the fact that they can include citizens from many states. If each of these individuals, having sustained some kind of harm, were to seek protection from their national state, that would lead to an unjustified hardship. Once again, the principle of the nationality of claims has to be seen in perspective, given the particular vulnerability of the people concerned. At regional level, Article 46 of the Charter of Fundamental Rights of the EU introduces another major exception to the principle of the nationality of claims. Indeed, the Charter provides that any citizen, any EU citizen, enjoys on the territory of a third country where in the member state whose nationals are not represented from the diplomatic and consular protection of other member states. Codifying this practice dates back to the Gulf War, and this exception is justified by the particular vulnerability of citizens. And the diplomatic protection, henceforth, can be exercised in respect of people other than nationals. By way of conclusion, the customary institution of diplomatic protection has moved substantially away from the traditional state approach. It's become more anthropocentric. More recent practice highlights that the discretionary power of the state is subject to restrictions and that diplomatic protection is no longer limited to the minimum standard of protection afforded to foreigners, but is exercised on a broader basis of human rights. Diplomatic protection, in the last analysis, is a way of protecting human rights, including those of non-nationals who are particularly vulnerable, like stateless persons, refugees, etc. Thank you.
Je remercie beaucoup le professeur Sicilianos pour avoir surtout.
Allow me to thank Professor Sicilianos very warmly indeed. Thank you also for sticking to your speaking time, 10 minutes. The third speaker for this particular panel will be Professor Maurice Kamto. And the professor is going to speak to us about the humanization of public international law in relation to mechanisms of protection of human rights. Mr. Kamto is a professor at the University of Yaoundé in Cameroon, and furthermore, he is a member of the Curatorium of the Hague Academy of International Law. Professor Kamto, over to you. Thank you very much. Thank you, Chair, Your Excellencies, ladies and gentlemen. allow me to revert to the previous panel. The previous panel asked whether human beings were center stage, at the center of it all. But regardless of where we are, I mean, if we're at the center, what really matters is what we do at the center. Look at the Netherlands. Look at this green landscape behind us. You see, human beings can do good things. We don't just destroy. We can actually do something positive. And since we're talking about human beings, individuals, there's no point in developing beautiful rules, fine-tuned theories. I think, in a way, we need to come down a notch or two, down from this theory, down to the level of the human being, the vulnerable, fragile human being. That is what this panel is addressing, talking about the humanization of public international law and practice in particular. What happens in terms of the human being, the vulnerable human being, when it comes to international law, when it comes to international rules of law? What happens, in effect? You have a United Nations system. The United Nations system is both the normative, I would say, and the institutional matrix for the humanization of international law in practice. You have the UN Charter. The UN Charter, I think, reflects this desire to build something, to build an international system where the human person is center stage. From the very beginning, this charter affirmed, amongst other things, this resolve of the peoples of the United Nations. It wasn't the states, it was indeed the peoples, we the people. And I would like to quote, "We reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women." End of quotation. Under the influence of this charter, member states then developed an institutional system that is geared towards the implementation of policies that are there to help, to assist human beings. You have the FAO, you have the International Office for Migration, you have, of course, the WHO, the World Health Organization, you have the World Food Programme, UNICEF, and so on and so forth. All of these bodies are there for that. And at the same time, our standards for the protection and the preservation of fundamental human rights have developed. They've developed thanks to a network of international instruments, and this network has been constantly expanding since the middle of the 20th century. The original ambition was to humanize international law. And indeed, the Universal Declaration of Human Rights of 1948 was the touchstone of that whole effort. And that, of course, as we know, unfortunately stalled over time because of a proliferation of armed conflicts, either international or domestic armed conflicts. And also it stalled because tensions reappeared in many countries, in countries where human rights were really put to the test, in effect. So faced with this situation, faced with these problems, what we now need to do is come back to the original humanist purpose of the whole UN endeavour. Let me therefore say a few words about bureaucracy, the red tape that has bogged down the original intention of the UN Charter. With reference to that, I would like to make a few brief remarks on the processing of individual complaints by those who are victims of serious violations of their rights. These are known as communications. Their examination by the competent treaty bodies that are provided for in the various human rights treaties adopted within the framework of the UN Charter. I think it's important to recall that the human rights treaty bodies are composed of anything from 10 to more independent experts, 10 to 25, I would say, 10 to 25 by committee. And the mandate of these experts is derived from 9 core treaties and also from the optional protocol to the Convention Against Torture. That is what it's rooted in. Now, with the exception of the subcommittee on the prevention of torture, their mandate as experts is to receive and to examine reports submitted by states parties, going into the very fine details of these reports and to look at how they are implementing treaty provisions. 8 of these treaty bodies, under their respective optional protocols or under their specific provisions, 8 of them are also empowered to receive and to consider complaints or communications from individuals who allege that their rights have been flouted, provided, of course, that the state in question has agreed to such a procedure taking place. As for the Subcommittee on the Prevention of Torture, that subcommittee has a mandate to visit any place where persons are, or indeed may be, deprived of their liberty. And this prerogative is a very important prerogative. And if it's implemented, it would really give substance to this idea of the humanization of international human rights law in practice, because it would make visible this concern for persons in distress. And I'm sure that these persons in distress were the ones that inspired the establishment of the subcommittee in the first place. It would operationalize that effort. The treaty bodies perform a number of other functions or roles under their respective treaties, for instance, emergency interventions, conducting inquiries, requesting further information on the implementation of the treaties. These are also known as follow-up procedures, handling complaints coming from states addressed against other states, general comments, and also so-called early warning procedures. I think it's been agreed that the special procedures can be initiated without necessarily having to exhaust domestic remedies first, or indeed for the state concerned to be a party to the relevant treaty instrument. These are not prerequisites. So it goes to show how this task entrusted by states within the United Nations to these so-called treaty bodies and to the special procedures under their aegis, how promising that was as a design. However, if you look at reality, the reality is, I think, not quite what we would hope for. It's frankly disappointing in some respects. There was more of a decade of unsuccessful attempts to strengthen the UN treaty mechanism. This UN treaty mechanism was then again the subject of a review in 2020, a very thorough review, the purpose being to reform these treaty mechanisms. And what we noticed was that the whole system had entered into a phase where there was fatigue regarding these procedures. It was all very difficult in the committees. The positions were very scattered. Now, from the point of view of the victims, and after all of these mechanisms were created precisely for these victims. From their point of view, the effectiveness of these mechanisms is questionable, is moot, particularly if you look at the very long delays between, on the one hand, the registration of a communication, and then on the other, the rendering of a relevant decision in the matter concerned. Some of these mechanisms have the possibility of carrying out investigations on the field visits, if you like, on the ground, but it's hardly ever used, and it's unable to produce the results that you would hope for or expect. Another shortcoming of this system has to do with the various aspects of the procedure used by these mechanisms. In fact, there was a stock-taking exercise undertaken by the UN General Assembly in 2014 where they took stock of how the mechanisms were working. There was underperformance on the part of the treaty bodies, that was the conclusion, and some of the reasons had to do with gap between the inflated mandates of these committees and then the insufficient financial resources allocated to these committees. And when it came to the Subcommittee on Prevention on Torture, the UN Secretary-General actually stated in 2018 that it had to reduce the number of field visits from an original 10 to 7 or 8 a year. And the Secretary-General added, given the current number of ratifications, it would actually take the subcommittee more than 10 years to visit all the states' parties, where it's supposed to carry out these field visits. So improving the performance of these UN human rights treaty mechanisms is also something that would require a proper composition of these various mechanisms. And you'd also need a redefinition of the profile of the experts. The experts must truly be experts. The experts should never, ever lose their independence. And in that regard, I think it might be useful to flag here the fact that there's still an omnipresence of states in the selection procedure of these mandate holders, and also this underlying issue of possible political influence when it comes to the handling of certain cases, certain dossiers. I come to my last point, and I wish to touch upon the need to rediscover the humanist purpose of the UN project. perhaps you could say here that the effective humanization of the practice of international law is something that requires that the human person be effectively taken into account by the rule of law. Human rights are not like other rules of international law. They are not applicable ab intesta. There is a rule on the delimitation of borders, for instance, whether you're talking about maritime or terrestrial borders. That rule will be addressed to a state, the state as a legal person, in other words, as an abstract being. The representatives of that state will come before a dispute settlement mechanism and body and will argue. They will argue with varying degrees of passion, perhaps, but they will argue that, this is their position. But their position is never that of a plaintiff, a genuine plaintiff whose life is in danger. And it's precisely that position that persons involved in human rights violations or disputes find themselves. For the state's representative, a dispute is a dispute. It's a file like any other, a case like any other. The state representative represents his state or her state and just wants to defend the state, protect the state's image. The plaintiff, however, the appellant, for him or for her, the health is at stake, the future of the family, the life in general of that person. All of those issues are at stake. And that's why I would say that this kind of procedure is not like any other, certainly not internationally speaking. So to be very specific, the humanization of international law is something that would recommend or advocate contact between the complainant, and the reality of the situation of that plaintiff. A kind of procedural due diligence, which would, I think, require a review of existing mechanisms in order to provide better human, material, and financial resources for these mechanisms, and also to try to shorten the time that it takes to examine these appeals or petitions. Humanization is also something that emphasizes the need for reparation. This has been mentioned already, effective reparation and prompt reparation for the victims of serious human rights violations or indeed international humanitarian law. Reparation must be prompt. So this holds true for human rights treaty bodies as well. We expect them to be flexible in terms of their functioning, and we expect them to be speedy. The procedural rules should allow them to act speedily and effectively with a view to guaranteeing better implementation. A lot still remains to be done, I'm afraid. We need to convince international legal scholarship, and we need to, of course, convince all the states of the fact that the fate of humanity surely must be above the will of a state. At least that is a hope that I think we can all share. International law recognizes the status of the individual by granting him or her some rights that are their rights, including access, although it's quite limited access, to international justice. So where that is true, where that is already achieved, then it's very important for the international mechanisms to protect or to guarantee these rights, that these mechanisms carry out their mission properly with awareness of the extreme vulnerability of the individual in the face of the omnipotence of the state. Thank you.
Je remercie beaucoup.
Thank you. I would very much like to thank Professor Maurice Cantu for his intervention, and I would now like to give the floor to Madam Judge Maria Teresa Infante Caffi, who is a judge at the International Tribunal for the Law of the Sea, and she will be speaking in English, and she will speak about the new avenues for the humanization of the law of the sea. Madam, you have the floor. Thank you very much, President. I thank the Academy of International Law. It's a great honor for me to be here and especially to take part in this incredible debate of such a high level. But I will be speaking in English.
That is an invitation to conceive the law of the sea as a delicate balance between the need for certainty and stability, together with economic and social development needs, using the ocean and its resources and the conservation and management of the resources in a sustainable manner, looking at the protection and preservation of the marine environment. This is one perspective. There are many others that are also competing in the international arena. All of this considering the very diffuse authority of states. We have spoken today about sovereignty as a very strong, a very certain entity that states possess or have, but I think sovereignty sometimes that has very little below the state as defined as an institution itself. This is it poses the scenario I'm going to speak about poses very certain complexities. Relationships are not easy to understand sometimes, but when we analyze the contact of states and their agencies, their intercross with other states and non-state actors, the involvement of several stakeholders, and the nature of the problems that are addressed by tribunals, we see that the situation is not simple and is not very transparent on many occasions. In respect of this subject, it is worth mentioning that there have been contributions of renowned jurists and judges, Oxman, Vukas, Treves, and Die, among others, who have anticipated or have elaborated on many of the questions I'm going to address. In the writings, it is noticeable to look at the grounds to connect human rights and the law of the sea, either from the perspective of the United Nations Convention on the Law of the Sea, or customary law, or some other specialized instruments themselves. The current debate shows a standpoint in which the UN Convention on the Law of the Sea and its implementing agreements with their governance systems and compliance mechanisms set forth in them are also looked as a means to assess responses to sustainable development demands. So the relationship between sustainable development demands, human rights, and the humanization of international law. A methodology that considers that threats to the marine ecosystem and their consequences for the population or the situation of coastal communities are matters of law of the sea interest. This is a new approach, not new today, but it is in terms of decades. This approach intends to bring coherence to responses instead of applying sectoral or fragmented perspectives to address certain issues. These characteristics have been noticeable in the negotiation of a draft agreement under the United Nations Convention on the Law of the Sea on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction, a very long title. The final negotiated text includes a set of general principles and approaches in Article 5 that combine notions based on the Convention and others inspired in other international agreements and declarations, while acknowledging the diversity amongst countries. So it is a very complex article that will operate, when we have to interpret the future convention, they have to operate as a unit together. Recently, an advisory opinion request has been presented by Colombia and Chile to the Inter-American Convention Court of Human Rights to address, among other questions, the scope of the state's duties on prevention with regard to climate events caused by global warming, including extreme events and slow onset events based on the obligations under the American Convention on Human Rights, in light of the Paris Agreement and the scientific consensus which recommend that global temperatures should not increase beyond certain degrees. Another question referred to the court is about the conduct of states, the conduct that states should adopt to regulate, to monitor and oversee, as well as to request and to adopt social environmental impact assessments, to establish a contingency plan and to mitigate any activities under their jurisdictions that exacerbate or could exacerbate a climate emergency. So many questions that the responses of which should be found in international environmental agreements, climate change agreements, and so on, but from the perspective of human rights. And the law of the sea is not specified in the presentation, but I'm absolutely certain that they will be present in the responses that the court will have to create or set out. It should not be left out of consideration the pattern set out by the advisory opinion of the Inter-American Court in 2017, titled Environment and Human Rights, State Obligations in Relation to the Environment in the Context of the Protection and Guarantee of Rights to Life and to Personal Integrity, Interpretation and Scope of Articles 4.1 and 5.1 of the American Convention, that was requested by Colombia with the support of some auditors in this room. In this request, references to the marine environment in the wider Caribbean region was cited, and the court was asked about the Pact of San Jose, the American Convention on Human Rights, as the basis for interpretation of those environmental treaties. So quite a complex picture and a challenge, and the court delivered an opinion which is a very important perspective to understand the relationship between the law of the sea and human rights. Among other assertions, the court referred to the duty to act with due diligence as a concept whose meaning is determined by international law that has been used in other fields, including international humanitarian law and the law of the sea. Then there is another advisory opinion request before the International Tribunal for the Law of the Sea that was submitted by the Commission of Small Island States, and posing questions regarding the protection and preservation of the marine environment in relation to the climate change impact, including ocean warming and sea level rise and ocean acidification. To what extent these phenomena encompass issues particularly related to human concerns will be part of the analysis of the tribunal. In this case, the submission expressly mentions Part 12 of the UN Convention and the UN Convention on the Law of the Sea. A third request that is here in The Hague, presented here in The Hague, has been submitted before the International Court of Justice, and it will also deal with law of the sea issues. Here, the request includes a reference to the United Nations Convention on the Law of the Sea, and specifying that it has to be looked at together with the duty of due diligence and the rights recognized in the Universal Declaration of Human Rights. That is an important opinion regarding the value of this Universal Declaration, and the principle of prevention of significant harm to the environment and the duty to protect and preserve the marine environment. So the law of the sea will be exposed to in different settings to human rights requests and questions. From a theoretical point of view, there is a reflection about the most appropriate approach to deal with these human dimensions, whether they should be related to persons or to collective units and other dimensions. From the outset, it is observed that in almost all cases and problems, there are questions in respect of the implementation of the law of the sea, of governance, regulatory schemes, along with compliance mechanisms. And on the other hand, the conception that the law of the sea should enshrine principles and rules that, together with other goals, contribute to the protection of people, providing duties and responsibilities to effectively protect human life, including, this is a debate that is also part of the debate before the civil authority, as the institution that has been created to implement the common heritage of mankind. It derives from the above that the UN Convention and related instruments are increasingly subject to different appraisals in respect of human rights, either to put the accent on the individuals or to look for responses at the collective purposes of international law. Among theoretical questions that may arise, I would like to highlight three among several others. Whether it is conclusive to look at the law of the sea, which is composed of principles and rules in isolation from substantive matters that are partially and simultaneously scrutinized from other perspectives. Questions related to jurisdictional matters and the status of natural resources, as well as their utilization, emerge in addition to views with a bearing on human rights and humanity concerns. Although those perspectives may not be present explicitly in the law of the sea provisions of the UN Convention, the relationship appears every time we address these complex issues. To what extent separate perspectives are realistic is something to test in practice. There is also a point of view as to whether the theory of self-contained regimes poses constraints to the application of the law of the sea to complex situations which could be analyzed from other legal dimensions. For example, in the framework of the Civil and Political Rights Committee, or the Human Rights Committee, the Civil and Political Covenant, and other premises. The situation of irregular migrants and people trafficking at sea, drug trafficking, salvage, and so on, piracy, and so on, pose the same question, either to have recourse to regimes that are self-contained and in isolation, or to interrelate among them. Another point may refer to the capacity of the law of the sea to address collective problems such as those posed by the environmental issues, climate change and so on, and matters related to the uses of the high seas and the zone, including security concerns. So is to bring into the law of the sea problems that may strictly relate to other areas, international legal areas. According to a series of decisions, courts and tribunals have followed an approach that integrates the concept of humanity in the assessment of particular situations. That happened in the case, I have 1 minute?
1 minute.
1 minute? Very good. In the case that was mentioned by Professor Sicilianos, the Saiga case, well, there's a very nice sentence there. Considerations of humanity must apply in the law of the sea as they do in other areas of international law. That is an inspiration from the Corfu Chali case. But the ITLOS went beyond and said, although the convention does not contain express provisions on the use of force in the arrest of ships, international law, which is applicable by virtue of Article 2093 of the Convention, requires that the use of force must be avoided as far as possible, and where force is unavoidable, it must not go beyond what is reasonable and necessary in the circumstances. There are other cases in which the ITLOS has referred to this very important dimension and domain. A variant of this, with this I finish, of this perspective may arise from specific maritime regimes that entail functional competencies on the seas and their bearing on human rights matters. That is the core of the decision adopted by the Committee on Human Rights and the optional protocol on civil and political rights covenant. So there are several areas. I have not depicted all of them. I have more, but with this I conclude my presentation, and I thank you very much. Thank you.
I would like to thank Madame Infante Caffi, judge of the ITLOS, but I want to add also that she is a new member of the international, a new member of the Curatorium of International Law Academy. Thank you. Je me tourne vers. Est-ce qu'on peut prendre?
Do we have time for a few questions, Secretary General? Mr. Touvenat, unfortunately, off mic.
Deux questions. Bon.
We can have 2 questions, can we? Very well. 2 questions.
Ricardo Abello, Université de Rosario.
From Bogota, Colombia, University of Rosario. Well, you all spoke, and also, in fact, Judge Benuna, earlier on spoke about this dialogue between different courts, tribunals, and how the ICJ is starting to quote other tribunals, other courts. And Maria Teresa Infante, Madam Judge, Madam Justice, you spoke about 3 advisory opinions, which are pending before 3 different courts simultaneously. I ask the panel, how do you see the dialogue between these different courts panning out, bearing in mind that there's a lot of commonality between the different points raised across the board? Thank you very much, says the chair. Another question? We can allow one more question. A second question, please. Please go ahead. Yes, I come from the Seville University, and I have a question which is for Mr. Sicilianos. You spoke about a number of cases, and you spoke about diplomatic protection, and you spoke about the way in which that works out over time. So I'd like to ask you for your opinion regarding Russia, the case before the court, the International Court of Justice. And there was some difficulty. It actually concerned Georgia and Russia, and it was difficult to pinpoint exactly the ground for the complaint. Was it diplomatic protection? Was it Georgian discrimination against Georgia by Russia? Was that the ground? Bearing in mind, of course, that the claim was of a territorial nature, and within that territory there were individuals who were not Georgian citizens as such. They didn't have the nationality. So I'm thinking of that case. There's also Armenia, Azerbaijan, and vice versa, Azerbaijan against Armenia. Again, these questions arise. Will these cases be going forward, bearing in mind the circumstances? Thank you very much. I'd like to hear your opinion. Thank you, says the chair. So 2 questions were put by the audience. Thank you very much for that. The first question was addressed to Judge Infante Caffi. Would you like to respond straight away? Is this a good time? Please go ahead. Thank you very much. Thank you, Chair, and thank you also for your question. It's a question that could actually be the subject of a roundtable in itself. There are so many different opinions on this matter, a lot of food for thought. But I think you need to make a distinction. There's a constant dialogue, a permanent dialogue that goes on when it comes to reading decisions adopted by other courts, other tribunals. These are read. You know, Hamburg, or indeed The Hague, or Costa Rica. It'll depend on the subject, of course, but I think there is some cross-reading. In terms of perceptions, you know, on human rights, for instance, is there a difference between Hamburg and The Hague? The individual as a human person who appears before the court completely on their own, so to speak. And in a way, the court, I think, extends the margin for interpretation. It bases itself, of course, on the Charter, but I think that there's a certain expansion. I mean, again, it's very interesting. It's also to do with the political environment. You know, the tribunals, I mean, ITLOS here or elsewhere. You know, we have our decisions to take. I don't know whether the Inter-American Court will be taking its decision before we have our session here. I don't know. But in terms of the comments made between general points of law and then obligations that are derived from these general points, I think that these comments will be read very carefully. I hope that answers your question. And in terms of the 2 interstate tribunals, I think that they will have major responsibility to bear to make sure that there is consistency, coherence in terms of this case law. Here I'm talking about the question of climate change. I think it's actually very interesting. I'm sure they're going to work well, and hopefully they will also read one another's opinion. I don't know whether they'll cross-reference necessarily, but I think they will read. Thank you. The second question was addressed to Professor Sicilianus. Would you like to respond? Thank you. Thank you very much for your question. So, Georgia v. Russia, International Court of Justice. It's based, as you know, on the Convention for the Elimination of Discrimination on the Grounds of Race. And therefore, I don't think you can actually approach it from a diplomatic protection point of view. But there's also Georgia versus Russia Mark II before the ECHR, the European Court of Human Rights. So there's another case. In the phase where they were looking at just satisfaction, i.e. compensation, there the ECHR made reference to the other opinion and also to the recommendations of the committee that looked at the way in which reparations should be handed out. So at least it was looked at from that point of view, reparations, compensation for damages. And from that point of view, it was seen as a diplomatic protection case. It was analyzed on that basis. And the same holds true for Georgia versus Russia #1, a previous case. You had there a list, hundreds of individuals. Georgia put that list to the court. These individuals had been identified. They were clearly identified. And I think that that is, in fact, the term used by the European Court of Human Rights. You have to have a group of individuals and they have to be identified. The court will always ask the states to give them a specific list, a tangible list. And there was also Cyprus v. Turkey. Again, you had two groups. You had the individuals who'd gone missing on the one hand, and then you had the individuals in the enclave under northern control. So in both cases, we were talking about victims that were identified, identifiable and identified, and there was a list. The court requested a list, and the list was indeed provided by the state to the court. And on the basis of that list, the court was able to calculate damages to be awarded. The European Court, I don't think it's a great secret that I'm revealing here. They have a method. The court has a method for calculations. It will be dependent on the seriousness of the violation, the cost in terms of human lives. I mean, obviously, human life does not have a cost attached to it, but there is compensation awarded according to the impact it has on human life. So for violation X, so much, for violation Y, so much, and then you can multiply that by the number of victims. And we're talking about millions. Georgia versus Russia #1, and I think it was something like 80 million in Cyprus v. Turkey, and 85 million, if memory serves me correctly, on the Georgia versus Russia Mark II case. So it's arithmetics. It's mathematics, if you like. It's very specific. There is a method for working this out. And to draw up this method of calculation, in 3 interstate cases, the court referred to the International Law Commission. It referred to the question of diplomatic protection. So in a way, the analysis incorporates that notion of diplomatic protection. It's more geared towards that side of things, towards that side, rather than the ICJ, perhaps. I mean, the president of the ICJ is in the auditorium right now, so I stand to be corrected by her. But the analysis of the case Georgia v. Russia here, I don't know whether it incorporates a diplomatic protection angle. But for the European Court, when it comes to calculation of reparations, there the analysis was clearly based upon diplomatic protection, no question about it. It is the structure of the ruling, it is the logic of the ruling, right all the way to the end. And again, references to these points I mentioned. So that is why I spoke about a practice, in particular a case law practice, which is constant in nature. Thank you. May I come back to the first question, says the chair. This fear, I think, was already present when the first case arose, delimitations, a case put before the International Tribunal. But at the time, the fear was not translated into anything tangible. there was no fragmentation between the criteria that would be applicable in these cases, whether you're talking about the International Court of Justice or indeed about the tribunal. So it didn't materialize. Thank you.
Je crois qu'il fallait.
Thank you. Well, we didn't catch up on our backlog, I'm afraid. No surprises there. It is now 5:03. We started, of course, the last panel a little bit late, half an hour late or so. We still need a break, though. You might want to take a little walk, stretch your legs, take a cup of tea, cup of coffee. Please come back in 20 minutes' time, because the last panel is very interesting. We'll be looking at the humanization of private international law. We're going to hear some really important experts from the field of private international law. So a 20-minute break, no more than that. See you back here.